Hi, I'm Sonia Kamat. I'm Assistant Professor in Law, teaching in Rosary College of Commerce and Arts, Navali, Goa. Today I shall be talking about arbitration. What is arbitration? Basically, arbitration is an alternate dispute resolution method wherein the parties to a dispute refer it to one or odd number of persons called as arbitrators who pass the award. So, when we consider arbitration, it's an alternate method to litigation method. Many people prefer to go to court to resolve their dispute. But because of various disadvantages pertaining to the court system, we have an alternate method to resolve this dispute, and that alternate method we term it as arbitration. In India, currently arbitration is governed by Arbitration and Conciliation Act 1996. What is arbitral tribunal? It consists of panel of one or more adjudicators called as arbitrators to resolve the dispute. So basically, arbitration is a process where you appoint people as adjudicators. These adjudicators are called as arbitrators under arbitration. Now you can have either sole arbitrator or odd number of arbitrators. The reason why odd number of arbitrators are appointed is to avoid clash of decisions. In case if there is any clash of decisions, the chairman or the umpire, who is the odd number, whose decision will be final in that regard. So generally, in arbitration, either there is sole arbitrator or odd number, which is generally 3 numbers together. The next question which comes up here is, then who can be appointed as arbitrator, or who is qualified to be an arbitrator? Arbitration and Conciliation Act 1996 do not provide any specific qualifications to appoint an arbitrator. Basically, he has to be a person of age, that is major in age, and of sound mind to be appointed as an arbitrator. So it's entirely the discretion of the parties at dispute to appoint any person who is major and of sound mind to act as arbitrator to decide the dispute. Since now we are talking about arbitration and it's a recent method or new method to resolve dispute, question arises is, why arbitration, or what are the advantages of arbitration when we compare it to the litigation process? There are different advantages why one should try for arbitration. First and foremost, we can consider it as faster disposal of cases. There is always inordinate delay in disposal of cases before Indian courts. Backlog of cases are crippling judiciary to the core. If we go through the statistics, as on 1st June 2019, around 58,000 cases were pending in the Supreme Court. More than 43 lakh cases are pending in the 25 high courts in the country, and over 8 lakhs of these are over a decade old. But when we compare this to arbitration, it involves faster disposal of cases. The reason being, as per the recent Amendment Act 2019, arbitrator has to complete the proceedings of statement of claim and defense within 6 months, and thereafter he should pass the award within 12 months from the date of completion of pleadings. Now, let me tell you all what is statement of claim and statement of defense. Since arbitration is a process to resolve the dispute, there are two parties. One party is the applicant, who comes before the arbitrator with a problem or a dispute to be solved. And the person against whom this case is filed, we call him as respondent. Now, the petitioner or the applicant has to submit his facts before the arbitrator. These facts are stated in a document called as Statement of Claim. Thereafter, respondent in his defense files a statement which is called as Document of Defense. So these things have to be completed within 6 months from the date of commencement of arbitration. Thereafter, after hearing both the parties and after leading evidence, arbitrator has to give his final decision, which we call it as award, within 12 months of completion of pleadings. So since there is time limit for arbitration, it is much faster in disposing cases when we compare it to normal litigation process. Since there is faster disposal of cases, it is pertinent to note that it will be less expensive than the normal litigation process. It's not completely cheaper, but when we compare it to the litigation process, it is much less expensive since the entire process is much quicker. Next advantage of arbitration is finality. Now, what do you mean by finality? Arbitral awards are generally not subject to appeal. However, when we compare it to litigation, we have hierarchy of courts where we can appeal up to Supreme Court. But when we consider arbitration, they are open to challenge, but the grounds of challenging award are very limited. They are mainly procedural grounds. For example, if there is lack of proper notice for appointment of arbitrator, or arbitral tribunal is not properly constituted as per the arbitration agreement, or non-arbitrability of subject matter, or the award is in conflict with public policy. So these are only few grounds where award can be challenged. Again, if there is lack of independence or impartiality is challenged, then also award can be challenged in this regard. So these are the few grounds, and as such we can say that arbitral awards generally attain finality once they are passed, with the exception of these grounds. Next advantage of arbitration is flexibility and less rigid procedures. When we talk about court system or the litigation process, it is always governed by rigid procedures beyond understanding of a layperson. They are so complicated procedures and they are so rigid that they have to be followed in the court system. Without following these procedures, the case does not move further. But when we talk about arbitration, the procedures are much less rigid. Reason being, the parties are free to decide their own procedures to be followed in arbitration. Although the procedures can be decided by the parties, they should not be in conflict with the Indian law. So in that regard, a lot of flexibility is provided in arbitration. Secondly, we can also talk about flexibility with reference to the timing of arbitration proceedings and the choice of place. These both factors can be decided by the parties and the arbitrator themselves as per their convenience. This choice, however, is not available in the litigation process. Final advantage of arbitration rests in its privacy. Yes, court systems are known for following the principle of open court system. Basically, open court system means justice has to be done openly, that is in public. Anyone can have access to the hearing of the matters in the court. The principle followed in court is justice should not only be done but should also seem to be done. And that's why they follow this principle of open court system. With the exception of in-camera proceedings in the court, all other matters are held openly in public. However, this feature is not there in arbitration, and as such, privacy of the parties and their matter is guarded in arbitration. Along with that, there is a confidentiality clause which binds the parties and the arbitrator, by which they are not supposed to disclose the proceedings to anyone else. So it completely maintains the privacy with regard to the proceedings and the matters in the arbitration. So these are the advantages of arbitration when we consider it in comparison to the litigation process. Now, in briefly, we'll discuss about the arbitration process. Arbitration process moves through 5 different stages. First, if anyone wants to go for arbitration, there has to be a dispute. Again, the dispute should be pertaining to subject matter for which arbitration is available. It has to be noted here that there are certain disputes which are beyond the jurisdiction of arbitration. Example, criminal matters. They cannot be decided through arbitration. It has to go through the normal court system in any criminal matter. So, to start an arbitration process, we need a dispute which will be within the purview of arbitration process. Next, we need arbitration agreement. This is a very important factor if anyone wants to invoke the arbitration proceeding. Now, basically, arbitration agreement is an agreement to refer dispute to arbitration. So either this can be in the form of a separate agreement or it can be in the form of a clause. But it should clearly specify that parties intend to refer their dispute to arbitration and they don't want to go through the normal litigation process. The dispute which can be referred to arbitration can be the present or future, which means if the dispute has already arisen between the parties, that we call it as present dispute. So once the dispute has arisen, thereafter parties enter into arbitration agreement to refer the dispute to arbitration. That is called as present dispute to arbitration. However, under Arbitration and Conciliation Act 1996, you can also refer future dispute to arbitration. Future dispute means at present dispute has not yet arisen, but before the dispute arises, parties enter into agreement to the effect that in future, if any dispute arises with respect to the subject matter, they will go to arbitration. Example: partnership agreement. If partners enter into an agreement and in that they mention a clause to the effect that in future, if any dispute arises pertaining to the partnership agreement, we shall refer it to arbitration. This is an example of future dispute. Reason being, the dispute is currently not there and in future they will go for arbitration. So either one is allowed under arbitration agreement. Once the dispute is referred to the arbitrator, next step is appointment of arbitrator. Generally, the qualifications of arbitrator are mentioned in the arbitration agreement itself. In that case, arbitrators has to be appointed with reference to the qualifications mentioned. He should be appointed as per the choice of both the parties. However, if parties are unable to decide whom to appoint as arbitrator, the Act gives a provision to make a reference to the Chief Justice of High Court or Chief Justice of India with regard to appointment of arbitrators, in which case the decision of Chief Justice shall be final. Once the arbitrators are appointed, the next step is hearing both the parties and leading of evidence. Arbitrators are required to comply with principles of natural justice, which means arbitrators should be impartial. They should hear both the parties. They should give equal chance to both the parties to represent their case and then should pass the final decision. So hearing both the parties is an important component of arbitration. Final process of arbitration involves passing of the decision, which we call it as award. Award is basically the final decision of arbitrator. As I discussed earlier, this award is generally not subject to appeal with the exception of few grounds which are mostly procedural grounds. Other than that, this award cannot be challenged. So basically it attains the finality at this stage. So this is the entire arbitration process in brief, how it goes about. Thank you.